So welcome to Live with Search Engine Land. This is our special CCPA and coronavirus edition. All editions are coronavirus editions, but this is our special California Consumer Privacy Act and Privacy Discussion edition. And I am honored and pleased to be joined by three experts on this topic who will bring different points of view to the discussion. And I'm going to let them introduce themselves. So why don't we start? I see you guys in a certain order across my screen, so I'm going to speak to you in that order. So Abby, why don't you tell us who you are?
Sure. Hi, everyone. My name is Abby Matchett. I'm leading our enterprise analytics practice at Bounteous, which is a digital consulting agency focusing a lot on the web space, the mobile app space, and the marketing space. And so I've been really involved in CCPA and privacy regulations in the past few months because it's impacting every single one of our clients. Whether you're, in the mobile development world, or you're building a new website, or you're engaging in retargeting and remarketing activity, we've seen a lot of changes in this space. So I'm really excited to be here and talk with Greg, Lisa, and Katelyn today a little bit more about what we're seeing in this industry trend. I have a lot of background in consulting with clients, working with small and large enterprises. So super excited to hear some of your questions too about your own organizations.
And on that point, before we go to Lisa, you can ask questions in the chat window, and we will get to those a little bit later. And we want to allow a lot of time for folks to ask very specific questions because this is a rare opportunity. So Lisa, take it away.
Thank you very much, Greg. Yes, I am Lisa Rapp, and I head up the U.S. data ethics team at LiveRamp. And LiveRamp kind of sits in the ad tech digital ecosystem, and we kind of help bring clients and advertisers and publishers together in order to be able to kind of do omni-channel throughout the ecosystem. I kind of have I've been in the ad tech industry for about 20 years now, both ad tech and martech, and have kind of a wide variety in my background, everything from heading up sales to leading product groups, leading identity in the past, and then now leading data ethics. Spent the last year preparing and getting ready for CCPA, which went into effect on January 1st. And now we are ready for it to be by the AG yesterday on July 1st. Actually, now he can come after people. And so basically been preparing for that as well as GDPR over the past couple of years.
Okay. Hi, Katelyn. Who are you?
Hi, Greg. I'm Katelyn Ringrose. I'm an attorney and policy fellow at the Future of Privacy Forum in DC. I work on federal and state privacy legislation from a policy and educational standpoint. FPF is a nonprofit. We work across various industries. We look at issues of emerging technologies, anywhere from health tech to connected cars. I'm really happy to be here with Abby and Lisa. And I think, too, I just want to say it's so great to be here the day after CCPA enforcement was set to officially begin yesterday. So happy late CCPA day.
A new holiday.
Not everybody is equally happy, I think, Katelyn, about that. So we started like 1 or 2 minutes early, so people may not have heard entirely your introduction, Abby, but that's okay. If you want to ask questions, just put them in the chat bar, and we'll get to them. And you can ask any question about privacy generally, CCPA, CCPA enforcement. So let's lay some groundwork for the rest of the discussion. So really briefly, and any of you can answer this, for those that might not be fully aware of CCPA, although it's hard to believe that there's anybody in digital marketing at this point that hasn't heard of it, what is CCPA and what happened yesterday? So anybody jump in. Katelyn, why don't you help us?
Sure. So as Lisa said, January 1st was the enactment day of the CCPA, and so California Consumer Privacy Act. And it's interesting that CCPA actually was proposed and thought of in 2017 and then proposed as a ballot initiative in 2018. So that was right after the passage of the GDPR, the Cambridge Analytica scandals, and these kind of pre-election worries and woes. So we can say that the CCPA was founded kind of amidst this general upheaval, and now it's being enforced in a pandemic, which is, I think, incredibly interesting. So the initiative itself, CCPA started off as a ballot initiative. It was sponsored by Alistair McTaggart and a few others, only one of whom who had deep privacy expertise. Alistair McTaggart himself is a real estate developer in California. And so he went to the myth behind this is that he went to a cocktail party and heard an ex-Google engineer saying that individuals would be scared if they knew what we did with their data. So the CCPA has evolved immensely since then, since 2018. And I think I'm very curious on how it's going to evolve. CCPA applies really broadly to residents of California and to certain covered entities, which I'm sure we'll get into. And I think we'll also kind of touch on this whole culture right now of canceling subscriptions and user access rights and rights of deletion.
Yeah, I was going to say, I think, Katelyn, you've hit on a couple of really good things, because when I think about CCPA, I kind of, in my mind, break it down into like, what was given to California consumers as their rights, and then what are the obligations of businesses. So when I was thinking about like how to apply it, to our business, that's the way that I broke it down. And so, I think most people know this, but just very high level, the CCPA gave California consumers the right to know what information is collected about them, the ability to access that information, the ability to opt out of sale, the ability to, not be to actually get a physical form of the information that a business has on them, and then the right to deletion. And so those are kind of there's obviously other rights as well, but those are kind of the main rights that the California consumers get. And then from a business standpoint, I feel like the main obligations that we had to adhere to are obviously updating our privacy policies, adhering to being able to fulfill on those rights. So fulfill on an access request or a deletion request, understand, and that sounds pretty easy, but in actuality, in my opinion, it's very, very hard to act on those things. And the reason for that is that in order to be able to fulfill an access request or a deletion request, on a California consumer, there are obligations that you have to provide the information for the previous 12 months, which means that then you have to, as an organization, know every bit of data that your company has, where it is kept. And for a lot of companies, data is kept in various different silos that is managed by different organizations and different people. So you have cross divisions and cross collaborations that you have to work through and with. And then you have to understand what the purposes of using that data is, and how long you're keeping that data before you can even respond to an access request and give that information back, or before you can delete an individual or opt them out of your system and ensure that you are opting them out of every single system that you might have them tied to within your organization. Go ahead.
Oh, no, sorry. I didn't mean to cut you off, Lisa.
No, go right ahead.
So I was going to ask Abby, what in a perfect world, if you're a marketing organization, a publisher, a marketing technology company, what should you have done up until this point? What should you have already done internally?
Right. So Lisa and Katelyn summarized, the laundry list of items that companies and consumers are sort of concerned about. And really, if you were paying attention 6 months ago, 12 months ago, you would have immediately contacted your Katelyn, your lawyer, your legal teams. And what we've seen is that companies have started to do that. They've contacted their legal teams to determine what data they have that actually constitutes sale, or what they're doing with that data that determines the right to sell. And that's a really unique point with CCPA that we haven't really quite gotten into yet on this conversation, and I know that we will. So I'll gloss over that a little bit for now.
Well, just for clarification, one of the provisions of CCPA is that the consumer has a right to request that the company does not sell their personal information. Right. Okay, just to clarify that.
Perfect. So really what we found is that, if you were in a perfect world handling CCPA for July 1, you would have conducted an internal assessment of all of your data alongside with your IT organization, alongside with your business analysts, and most importantly, your legal teams. And you would have said, what data do we actually collect on our customers? And how far reaching is this data? Once you actually gather that list, and that's extremely challenging when we think about the web of information we have, not just from mobile devices and not just from our websites, but any information that we might be pushing to our customers and consumers counts in this sense. So once you gather all that information, really what customers and clients have been doing is saying, well, what tools do I need to start to actually act on these regulations? So they'll go through, an internal discussion with their technology team to say, what do we need to do to be able to actually identify users so that we can delete this data, so that we can give them their information and give them the rights that they have under this new policy. So that's a second part, that a lot of companies have been walking through, is really the idea of, conducting an audit of what internal data we have, determining what our legal obligations are for that data, and then saying, well, what do we actually tactically need to do to enable users to be recipients of their own data? How do I get it to them? How do I serve it to them? How do I enable them to self-identify? And then also, how do I actually enable the opt-out enforcement? How do I stop the sale of this data? How do I turn off my remarketing activity that might be happening with this personal data? And so those are three big buckets of things that in a perfect world, by yesterday, you would have said, yep, Greg, I have this completely down, no problems here.
Right, and to that point, I saw some survey data in the last 48 hours that I included in an article that I did yesterday on Search Engine Land on this, that said basically 56% of the companies surveyed, and this was a small sample of only 218 chief legal officers or general counsels of technology companies. 56% of them were unprepared for one or more of the privacy initiatives going on, GDPR, CCPA, or all of the above. So most companies seem to be not fully in compliance. Is that consistent with what you guys have seen informally in your travels?
It is, Greg, and I honestly think that 56% say they're unprepared. There's probably an additional 20 or 30% that believe that they're prepared, but in all actuality aren't meeting their obligations for CCPA. So MIT conducted a few studies that are out there. There's more being conducted every day. But really, in reality, determining what compliance means for your organization is an ongoing and evolutionary challenge. So even if you feel prepared, the likelihood that you are 100% compliant is actually very low, and that's what we found for most of our clients.
Okay, so I want to back up a little bit. Lisa, did you want to add something?
No, I was just agreeing with exactly what Abby was saying, in that I also think that part of that is because the way that both GDPR and CCPA were written were very broad and open into interpretation. And so you can get many different lawyers and many different people reading the exact same passage and interpreting it differently. And so then they are applying those privacy or those compliance laws differently within their organizations. And so to Abby's point, they feel like they're in compliance, but we don't actually really know. I think that, now that July 1st has gone into enforcement, I think as, the AG goes out and starts, looking at different companies and making responses out there, we're going to start as an industry to understand really what was the intent and the purpose behind, what does really a sale mean? What really is a third party? How is the AG really thinking about some of these issues that I believe are still haven't been, as an industry, we haven't decided really what they mean and how to apply them.
So Katelyn, I want to. I think there's a question that we haven't really answered. It's sort of something pretty fundamental. Who does CCPA apply to? I mean, people have a vague sense that it has this national reach, but who does it actually apply to, from a publisher technology company perspective?
I think what Lisa said before about there being different obligations on companies and different obligations or rights for consumers is really correct and a good way to think about it. So in terms of businesses, we keep saying generally it applies to businesses. It's not the most precise. It actually applies to for-profit businesses that are doing business in California and meet certain thresholds, right? There are 3 thresholds. The first is a $25 million annual revenue. The second is having data over 50,000 plus consumers. And the third is having 50% of your annual revenue derived from the sale of personal data. Again, that term is frankly ambiguous right now.
Well, sale is broadly defined in the statute, and it's probably going to be further defined in the future, but it's pretty broadly defined in the statute. Because I know that there are some people who've said, well, we don't sell data, so we're exempt. But that's not entirely correct, right?
Yeah, and I think on the flip side, we talk about businesses, we also talk about consumers who are California residents. It's a really broad geographic scope. And while we have these questions about what constitutes a sale and what doesn't, and these compliance issues, these are big problems that we need to solve because this is a huge enforcement stick, right? Like GDPR has this enforcement possibility of having up to 4% of your worldwide revenue docked. But CCPA has even a bigger stick if you think about all of these kinds of small penalties really adding up. There are 40 million residents of California. So you could have costs in the easy billions for bigger than FTC consent decrees, bigger than anything that would be fined under the GDPR.
So let me just sort of push you a little bit on this point. So I'm a company. I sell electric bikes, and I'm based in New York, right? And so let's say I'm not making $25 million a year. I'm a startup. How do I think about GDPR? Does it, or not GDPR, CCPA? Does it apply to me? Should I be complying?
Yes. So if you California has a lot of bicyclists, Greg. So I think it's something to keep in mind. I think it's a big myth that a lot of companies think, I'm a startup, I'm a small business, I don't have something like a big email listserv or a lot of sensitive details about my consumers. That doesn't mean that the CCPA doesn't apply to you. Also, just because you're in compliance with the GDPR, that doesn't mean that the CCPA doesn't apply to you. So I think the first step for a company that's really having these, I guess, misconceptions is to figure out what kind of data they actually hold, what category that would fall under within the CCPA, what kind of guidance is out there for them. And there's a lot right now. But it's a massive misconception that just because you're a startup or a relatively small business that this doesn't apply. That might change though with the CPRA.
Well, let's not talk about that yet, because we'll talk about that. We'll talk about that later. But so who I want to draw as bright a line as we can, which is hard, I realize, because of ambiguity. But if I'm getting substantial traffic to my website, to use my current hypothetical as an e-bike startup in New York, if I'm getting a lot of California website traffic, is that enough to have CCPA apply to me? If my website reaches people in California and there's a lot of enough people coming to the website, does that mean it applies to me?
Let's say you have, it depends on your level of traffic, but yeah.
If I have more than 50,000,
Yeah.
uniques from California, I should consider it applying to me, right?
Absolutely.
Okay.
Absolutely.
All right. Good. Okay.
And then,
So
you
Go
have to
ahead.
think about what Katelyn said earlier as well, which is right now CCPA only applies to California residents. But what I have been seeing throughout when I've been doing my investigation is that it seems to be 50-50 as to the amount of companies that are applying CCPA rights to all of the United States or just limiting it to California. So I think that's something else that businesses need to think about is, are they going to limit those rights to California residents only or do it more broadly? And then also think about that from the standpoint of we have 14 other states right now who have, legislation somewhere along the process. And, what does that mean in terms of those going into effect, and how you as a company are going to handle, disparate rights when you have certain rights that apply to California residents, certain rights that are different that may apply to New York or Texas or Illinois,
Mhm.
all of that.
So
It's
what's your
always best to meet the strictest law there.
Yeah, so is that
Exactly right.
CCPA? Is that currently CCPA?
So CCPA is the strictest, most comprehensive state law that we have right now in terms of comprehensive privacy legislation, right? We had a lot of movement in the federal space, but we'll see what happens there. Also in Washington, we saw the Washington privacy bill fail for the second time last year. So for right now, yes, the CCPA is the lay of the land. We might see other states kind of jockeying for that spot, maybe looking more towards the GDPR, maybe looking to the CCPA in order to kind of create their own consumer protections.
So Abby, what is your recommendation to people that operate in multiple states? Should they be complying with CCPA and use that as the standard, or should they do what Lisa suggested some people might do, which is carve out California residents and the rest of the country?
So this is a really great question, Greg. And Lisa, I love how you were talking about the difference that you're seeing in the industry, because I want to pose a question back to individuals who are questioning this on their company. How can you on your website today identify if someone is or is not a California resident? So the difference here and the key takeaway is that they're a resident of California and they may be visiting New York State. And in our typical web tracking, that would be based on their IP address, which would be New York at that time. And so, again, there's this distinction that we need to make for residence versus just geolocation. And because right now we're not so global, but because we should expect a lot of global mobility in the future and also privacy regulations to expand, I would say that if your website is available to all users in California, but really if you get a significant amount of traffic from those California IP addresses already, yes, you 100% need to be thinking about CCPA. And if you can't distinguish between California residents without them self-identifying, that's going to make it extremely hard for you to actually turn off a lot of your cookies and a lot of your data collection automatically. So we can use things like geolocation and IP address, but it really doesn't actually encompass the power behind the California resident situation that we see ourselves in for CCPA. So I would say, yes, you do need to be concerned about this, even if you're not, 100% sold in California. California residents do travel, and also this legislation, we believe itself will be traveling to other states as well.
So at the risk of misusing this, so the simplest approach would be to apply the CCPA standard nationally, from a data collection and audit and all the rules that you previously described. Yeah.
Yeah, if you are a general company that has maybe one or two websites, maybe a mobile application, maybe you're sort of advertising out there in a few of the newspaper publications, applying this globally to your organization is actually going to be less of a burden, because you won't be sort of narrowing down and isolating all of those small inconsistencies that might happen with California residents. That being said, you have to be aware of what this is going to do to your data collection and determine if that is financially okay with you, but also determine if that is something that your company is comfortable explaining to others. So for example, if we allow users in New York or New York residents to opt out of data collection, just like we do users and residents of California, then we can expect to see a bit smaller remarketing audiences than we've had in the past. We can expect to see smaller audiences than we've had in the past for all of our efforts, and also less data. But that data will still be directionally correct. So again, it's best practices here. Most likely it will be easier for you if you sort of apply this logic across your websites, but you have to be aware of how that might impact all of the efforts that you're doing downstream, and explain that internally as well.
So I do want to get into the the implications for marketers in a couple of minutes. Let's talk about enforcement. So the enforcement deadline happened yesterday. So that means the Attorney General of California can now bring actions against violators. There's also a private right of action, meaning individuals can sue, and that is retrospective to January 1st, right? Have I got all that correct? Yeah.
Yeah.
Okay. So, but there's also going to be some people are anticipating there's going to be some flexibility or lenience and there's a 30-day window to cure the defect, right? Can somebody speak to that? What do you guys anticipate in terms of the practical effect of this deadline happening yesterday, and what about the 30-day cure period? Talk a little bit about that. Anybody? Katelyn.
I can say generally there's, it's really hard to read the future. We don't know how many enforcement actions the AG is going to take up. I know last year a lot of folks were saying, oh, well, the office can only handle like 3 to 5 major cases a year or something. And that was giving comfort to maybe small businesses or individuals who weren't processing a lot of data to say, oh, well, the AG is going to go after like egregious harms conducted by large tech companies. I don't think that's true. I think it's a very dangerous basis to operate on. We don't know how many cases the AG is going to enforce. He's been tweeting, he's been putting out press releases about how excited he is to start enforcement. I would be a little bit worried if you have that mindset. In terms of enforcement itself, 2.5 thousand for violations generally. That goes up in triplicate if you are an intentional violator of the CCPA, and that's that can be per incident, per individual. It can compound very quickly. That cure window is incredibly important as we move through this kind of uncertain phase, and I think is very wonderful. Of course, the cure window is very short. So we also
sorry to interrupt. Let's talk about what that means. So you as a company will get some notice from somebody, an individual or the AG, and they're going to say, here you're a violator under CCPA, right? And then you've got 30 days to rectify that problem. Is that a correct interpretation? And then if you do that, then there's going to be no liability for you.
Yeah, and so Lisa, were you going to say something?
I was going to say, I don't know that we know the answer to that, because there's still the $2,500 that can be out there per violation per California consumer, as Katelyn was saying earlier, and there's 40 million of them out there in California. The 2,500 is if you didn't do this like purposefully. It's 7,500 per offense if they find that you did it purposefully. So even though you have a 30-day cure window, it's not 100% obvious right now that even if you cure that you won't still be required to pay that $2,500 per incident, and what that could actually snowball into.
And Lisa, you and I talked a bit earlier about the fact that, let's be realistic, how many companies can actually meet the requirements in 30 days? Mm-hmm. I mean, it is going to be an extraordinary heavy lift for teams that are probably already understaffed. The people who are involved in CCPA regulation in companies are the people who are already on backlog until 2022. Right? They're going to be your engineers, your IT groups, your data scientists and analysts, your legal teams who are probably also knee deep in 30 other regulations. So the 30-day grace period, if we want to call it that, it's actually not going to be enough time to become compliant. And I think that's the biggest thing that we want to drive home with our clients specifically is, hey, if you're considering doing this, don't think about the fact that there might be no fine in 30 days. It's a really bad place to operate. Instead, we want to operate with the fact that, the AG is going to be able to easily see if you have a few things in place.
Right.
Do you have a link on your website that says, do not sell my data? Does this give a user the opportunity to self-identify, right? I mean, these are things that we can do and start to do while we are evaluating our data very quickly that can be really, really useful in just potentially avoiding attraction, but also starting the process. Because again, getting these tools in place in 30 days, if you think about your website's sprint process, I mean, it doesn't fit. It just doesn't quite work.
I completely agree with you, Abby. I will say that at least for us, I mean, we have been thinking about and actively getting prepared for CCPA for almost 13 months is as long as we're doing that. And to your point, looking at different vendors and tool vendors, talking with our own internal counsel, external counsel, being on various boards within the ad tech industry to understand what others were doing and how they were thinking about it and how they were applying it. But I think you make a really great point in that I think there is low-hanging fruit that you can and should be looking at. And I think the AG even said sometime last year that he would be more accommodating to companies that were not being egregiously just not applying CCPA, if people were at least trying to do the right thing and making efforts there, he would look more fondly on them than companies that were not doing anything. So to your point, I would say there are these things you can be doing 30, 60, 90 days from now, to at least be setting that foundation, as you were saying.
So let's talk about those in really specific detail. So if you're in a position where you haven't complied at all, or you're in the process and you're not totally compliant, or you don't know where you are, what specific things should you do right now to start on this process or to advance this process? I mean, Abby, you sort of talked about it from an operational standpoint, but what are the fire drill things that people can do right now?
Update your privacy policies.
Privacy policy. Yes, I was going to say the first thing, the fire drill, is get the legal team to update that privacy policy. I think all three of us would say that we've seen several privacy policies that haven't been updated for quite some time. And also CCPA gives you the ability to communicate and request that you communicate these updates to your consumers. So by doing this and sort of updating your privacy policy, that fire drill really should happen in the coming 30 days. And again, it does require speaking with your legal team and your compliance officers internally, which I think operationally is a challenge for a lot of us, is getting together that core group of individuals who are going to tackle this problem.
Katelyn, have you seen any model privacy policies that you could point to that are examples that people could follow or use as a template?
It's a great question. I don't have any off the top of my head. IAB and II have been doing a lot of work in terms of like plugins and tools that might be really helpful. I don't know if Lisa or Abby, you've seen the model privacy policies. I like to think that a model is a model and you should draft your own, and you should, the type of data that you hold better than a different company. You might have different processes in place.
So you referenced the IAB. So the IAB has a compliance framework. Are there third-party organizations that you can quickly look to help accelerate this process for you?
Yes. So IAB just recently released a new specification to help, especially digital advertisers, comply with CCPA. Under this new spec, publishers can signal to ad tech vendors or service providers that the user has exercised their rights, whether that's, I think this one is primarily focused on the right to deletion. That's very helpful. And I would, really consider looking to these kinds of tools as well as industry guidance and figuring out kind of where your company is in relation to others in the industry. It's always super helpful.
Okay, so back to this 30, 60, 90-day kind of idea. So you said update your privacy policy. What next? Do not sell links, I would imagine.
Do not sell.
Yes.
I think one of the next things that you can do is evaluate the tools that you have available to you. So we talked a lot about the idea of the opt-out links and the opt-out forms that we have available to us that we should be using for CCPA. There are tools out there and third parties that have built-in logic to scan your website for cookies, enable you to select those cookies for, deletion for users that choose to opt out. Tools that come to mind include OneTrust, TrustArc, a lot of larger scale implementations. And those vendors can really help guide you to a solution that's a little bit more plug and play than something that you might build in-house. So if you're saying in 30 days, I'm going to update my privacy policy, then in 60 days, you'll probably want to consider what vendor you can work with, or if there are any vendors that you want to reach out to that might be able to help you solve some of these issues.
Yeah, absolutely. I will echo OneTrust. FPF published a guide actually comparing the CCPA versus the GDPR alongside OneTrust. And if you're going to use a vendor or you're interested in moving forward, that guide is for free on our website. And if you are already in compliance with GDPR, you might want to know what you're already doing that's great and what you need to continue to do.
Yeah, and
And
then just to echo what Abby's saying, I think that also as you're thinking about these vendors, in kind of parallel path, you should also be looking, as we've talked about earlier, as to what data does your company hold? Like, where are you acting as a service provider? Where are you acting as a business? And where you are as a business, understanding that data that you're holding, where it's being held within your company, how long it's being held, so that you can feed that back into the tools that you're either purchasing or that you're going to internally create, so that when, you know, a Lisa Rapp or an Abby comes in from California and wants to do an access or a deletion, and we request our information, that you can actually return it to us, you know, within the time frame. So within CCPA, there are various time frames, some having to do with business days, some having to do with calendar days in terms of a business's obligation. So for instance, if I wanted to come in and opt out, you know, there has to be, you have to return a receipt within, you know, 10 days. You have to pass down deletions within 15 days. You have to respond to an access request within 45 days. If you can't do it in 45 days, you have to tell the consumer why, and then you can ask for additional 45 days. But there are obligations on the businesses that you need to be able to fulfill, and you need to be able to track and to be able to show an auditor or someone else the requests coming in and how you replied to them and how you were compliant in meeting those individual deadlines and dates. And then CCPA has an obligation that for the previous year, then you have to post that on your website the next year, the number of requests you had, the number you denied. So external tools are usually a great thing. One, because you don't have to build them yourself, but two, they also have this functionality built in that will help you comply with some of these things for CCPA.
Well, most California consumers, by my reckoning, even though there's a heightened awareness of privacy issues and people are very concerned about privacy and people like the idea of not having their data sold or used, you know, sent downstream to you know, to Facebook, et cetera, or to whomever, there's a lack of awareness on the part of California residents about their rights under CCPA. Most people don't know what they're entitled to do, what they're not entitled to do. Most of them, you know, the do not sell links have been buried on websites. So I would imagine you can push back on this. I would imagine there's going to be very little, you know, some of the demands that you just identified, Lisa, about show me what data you have, give me access to the data. That's probably not happening in the real world very much right now. It's mostly going to be about the AG and maybe third-party lawyers looking at your site and trying to determine whether you're in compliance. I mean, in this kind of fire drill mode that we're in, you need to have the outward-facing compliance signals ready, and the internal stuff has to be done, but that probably can come a little bit later. You
I think that that's true. I think that you have to have the outward things because I believe that that's the low-hanging fruit that the AG is going to be looking at. But I still think that the AG has written into the regs that you are required to send a receipt after 10 days, that you're required to send a deletion after 15 days. And if they come in and decide to audit you, I believe it's going to be a comprehensive from beginning to end audit, not just an audit on the low-hanging fruit. I think you might be able to not be triggered by the AG if you have the low-hanging fruit though out there, right? So maybe the AG doesn't necessarily come to you first, like today. If you have some of that low-hanging fruit out there, but he is going to, when they come in there, they're going to look to make sure that you are compliant with all of the regulations, not just certain regulations when they come in and do the audit.
Yeah, and I pushed back on that a little bit too, Greg. I think Californians do care about their privacy. We saw that really early 2018. Alistair McTaggart did a poll of Californians, and it said like 8 out of 10, almost 9 out of 10 Californians wanted this at the time ballot initiative to pass, right? And consumers might be confused about their rights, but that doesn't stop Facebook users from asking Facebook what data it has on them, or asking Google to give all of the information in a packet to them, right? So I wouldn't be surprised if we don't see a spike in individual access requests. Also, right now we're talking about human-directed access requests. What happens when you have bots, or you have services, you have apps that are able to go and make those access requests across every website you interact with?
I will also say onto that, Katelyn, that I believe that like for CPRA, it also has almost like a 90% chance of passing because so many California residents are in favor of it. But to your point, Greg, I think part of the issue that has come up with CCPA is that although CCPA is here to provide more rights to the consumer, at the end of the day, the burden is on the consumer. And what I mean by that is, as a consumer, you yourself have to go to each and every place that you conduct business with or have a relationship and yourself ask for that data. And so I think that that's part of the issue, where not every company is getting the same amount of access, deletion, and opt-out requests, because consumers care. Maybe they don't want information on one particular publisher or brand, but they don't mind it at another publisher or brand based on their trusted relationship or the value exchange they're getting at one or another of these places.
So I want to give you an anecdote, and then I want to move into discussion about how this is going to impact marketers on a practical level. So in my case, I'm obviously very aware of these rules, and I started, and I've spent a bunch of time in Europe under GDPR. And what happens is you get these cookie walls. In Europe, you get these cookie walls, and then they give you all these choices. And then you become exhausted by that, and you just hit accept all because you just want to read the article. And so it winds up having a very minimal practical impact. With CCPA, I started looking for the do not sell links and going through that process, and it's just a very, very painful process. And so I don't do that anymore, right? And I am a very sophisticated consumer, and I am not doing it. And so people who aren't aware of these rights and aren't going to take the time and effort to fill out the forms and provide the information that you have to provide under these different tools, I think the practical effect is you're not going to see a lot of people opting out unless it becomes very simple, and unless you get browser-based tools, which we talked about a little bit on the prep call, to make that globally possible. But before we get to that, I want people to. So let's answer a question that's been sort of lingering here, and it helps get us into the marketing discussion. So somebody's asking, Ruan, if I pronounce that correctly, or Ruan, how is this going to affect Google ad campaigns focused on California?
So in Google, Google has released a significant amount of documentation on their stance on CCPA as a processor of data, and then also as an advertiser. And there are things that you need to do to become compliant in Google Ads today to be CCPA compliant. And a lot of those are going to be around settings that you have in Google Ads, and settings that you also have in Google Analytics that you can use to say, do not collect cookies on these customers, these California residents, once they opt out. So while Google Analytics itself is actually CCPA compliant as a tool, what happens is the data that we collect in GA and then send to ads becomes non-compliant because it sort of is that act of giving information to another tool. And so what we see, and Google has some extensive documentation on this that we can certainly provide links in the chat too. But what we see is that you'll need to be able to say, okay, if someone has opted out, I need to turn off my remarketing pixels in Google Tag Manager, in GTag, whatever tools you're using to send these things to Google Ads. I need to actually turn this off. And I need to prove that I can turn these things off. And that is actually a technical challenge that tools like OneTrust and TrustArc can assist with on the site or on your mobile application. which are really useful. But
And
in general there, we do have work that needs to be done to be compliant when we're thinking about our ads.
same question with Facebook. Anybody have any advice or insight into comparable question directed toward Facebook? I know Facebook has written a lot about CCPA from a consumer standpoint. Here's what we're doing to comply for the consumer, but what about ads? Anybody, can you say anything about that?
On the ad side of Facebook, I'll be totally honest, I'm not as familiar with some of the procedures and policies that they've generated. But if you are using Facebook remarketing based on, any visits to your website, so if you have a Facebook pixel, for example, which is just a snippet of code that says this person was here, and then you're using that to actually sell or retarget later on in Facebook, you're going to have to sort of consider how that might apply to the CCPA regulation of what constitutes a sale. So if sending data to Facebook from your website enables you to generate a certain percentage of revenue every year, then that's going to be something that we need to evaluate, and Facebook will most likely have pretty extensive tooling there to accommodate turning these things off. Ads actually has a tool where you can say, just don't remarket to any customer that's physically in California at this time. There's a toggle that you can use. My estimation would be that Facebook would also, have something similar, and then also give you the ability to sort of select when and how you use your Facebook marketing campaigns.
Okay, so there's a lot of talk about, and then this has been true for quite a while, well over a year, the sort of migration from reliance on third-party data to first-party data. Can you guys talk a little bit about that from a, sort of at a conceptual level and at a practical level? What does that mean, and what should marketers be doing or thinking about?
Sure. Lisa, do you want to go first, or do you mind if I?
Sure, and then you just jump in there and you can give the practical. I would say definitely, first party data is moving into being king, right? And I would say that, gathering first party data, the first thing that brands and others need to do is ensure that they're building trust with their consumers. And so the first thing that you want to do is be as transparent as possible, using language that a consumer can understand as to what data you're collecting, and think very hard about what is the data you are collecting. Don't collect more data than you need. Understand how within the organization that data is going to be used, and who within the organization is going to have access to that. And then think about how long you're going to keep that data, and be able to articulate that to a consumer, whether that's in a privacy policy or in a banner, and make sure that they understand how that data is being used, because the transparency and the ability to opt out or say yes or no to that, giving consent, is going to build that trust with your consumers. And think about, how you can gather that information, whether that's through, creation of loyalty programs, or, special content, or things like that, where you can actually get your users to come in and authenticate themselves and want to come back. Think of the value exchange that you can create between yourselves and those consumers.
Perfect. I think, again, completely agreeing with Lisa. I feel like the benefit of first-party data here, or I'll take a step back. Historically, we've been so reliant on third-party data because it's so easy. Essentially, it's saying, okay, well, I'll just serve up information about what users do on my website to third-party tools, and then they have all of this other information that company Abby, doesn't have access to. So I'll just be reliant on their information to say who has a high propensity to purchase this product, who has a high propensity to become a repeat purchaser, and these propensity scores are really just statistics, right? And what's great about first-party data is we can actually use our own data that we've collected with machine learning models and other tools that are actually, again, just statistics. I don't even have to say machine learning, to say that if users exhibit a certain pattern, we know that they're more likely, or maybe more likely, to purchase our product. They may be more likely to use our service than user B. We can think of it as clusters, or forming these individuals into groups based on the data that we company, Abby, already collects. And by doing that, we can actually create our own marketing efforts, our own remarketing groups. We can send emails to people and spend time forecasting and planning communication to individuals who are more likely to be successful. So this is a shift that we've seen not just because of CCPA, not just because of IT,
because of the cookies also.
but because of cookies, yeah.
Yeah.
So it really all kind of comes together to say, if you haven't evaluated your first party data strategy, giving you another thing to add to the checklist today. Because I think realistically, we can do a lot of the behind the scenes black box magic that some of these third parties did for us internally. And we do have a lot of information about our consumers. And one last point that Lisa made that is 100% a conversation I have all the time is, well, this seems like authenticated experiences then are going to be the preferred choice for first party data collection. And by authenticated, we mean just having a login, having a user ID. That's absolutely true, but we also need to think about the user experience. If forcing everybody to have a user login or a user ID is going to deplete resources from your business, then it might be sort of a slow rollout to incentivize users to do that. Because once we do have a logged in experience and we are able to capture information across multiple sessions, especially as cookies go away, we're going to be able to activate on that data in so many rich ways that you might say, I don't even miss third-party cookies in the future.
So go ahead, Lisa.
I was just going to say, Abby, how do you feel like second-party data is going to come into this? So we talked about third-party data and now the rise really of first-party data. And I'm really thinking about, so second-party data is like two first parties sharing their data, right? And so I'm wondering, do we feel like second-party data is going to be able to come in and kind of take the place a little bit of third-party data? What I mean by that is thinking of maybe like an airline company and a credit card company both sharing their first-party data together. And so then that's creating that second party. And now each side gets more insights into each of their, overlapping audiences to be able to then be able to do more targeted or personal campaigns. Do you see the rise of second party data coming on now with this happening?
I think that is such an interesting question. And I would say that there's going to be a rise of all kinds of data sharing, if it's possible. But remember, these litigation situations that were happening all over the country are only going to become more strict. So while you may be able to get away with sharing your data with Visa for a while, I don't know if it's actually a sustainable long-term objective for your company. And also, if your consumers find out that you're doing this, are they less likely to have a favorable view of your brand? So while I haven't said that, I haven't seen that this isn't happening, what I will say is that most companies are actually having a hard enough time figuring out their own first-party data that they haven't quite gone the second-party route. But that is absolutely not to say that in the past we know credit card companies is a great example. We know people buy that data. Like we know that is out there and everywhere. And every time you sign up for a new credit card because they have a great deal, that you're just going to get all kinds of information about you out there. So that's definitely a possibility.
So Katelyn, I know you're eager to say something, and I want to sort of speed things up a little bit here as we approach the end of the call. So go ahead.
I would be very interested in the rise of second-party data. I do want to put up a red flag that we need to keep in mind that these are not just issues of privacy, but are also issues of competition and antitrust, quite honestly, right? So when we're talking about companies with a breadth of data types that are looking to work together, could this possibly create walled gardens where companies with a lot of data are really benefiting and small startup companies really aren't as much?
See Google and Facebook.
Yeah, exactly. Or, we're talking about a big airline and a credit card company. These are issues that we need to keep in mind. We don't want to put privacy at the forefront before we start really thinking about the impacts on small and medium-sized businesses.
So just really quickly, can each of you give me a sense of what you think the future holds for reliance, whether we call it second-party data, data partnerships, or third-party data? there are a lot of data brokers. There are a lot of companies that are offering to sell data or to use data outside of your own company to help you accomplish some marketing objective. What is the outlook for those, those kinds of relationships? Programmatic advertising, etc.
So I will close by saying that companies.
Well, we're not quite at the end. We're not quite at the end.
But I'll say that for this answer, Greg, I'll say that companies are going to evolve, and so are these third-party data source companies and second-party data source companies. They're going to continue to evolve as well. And a prime example of this is Google's Sandbox, right? They're opening up their privacy options to be open source. They're basically saying, hey, we know that we're going to have issues with third-party cookies, and we know that they're going away, and that Chrome's going to start blocking these things in several months, and we know that that's going to happen. Tell us how to fix it is literally what they're asking the public for in their privacy sandbox. So what's going to happen is new technologies are going to actually arise that are going to enable you to better interact with these second-party and first-party resources, even your own resources, to sort of combat the idea that we're no longer going to have the same reliance on some of the third-party data. And I think that this evolution is going to keep going and going and going, just like browser evolution, just like privacy policy evolution. And so I wouldn't say that we'll completely strip ourselves of the need for that and only use first-party data. But what I will say is, there's going to be a lot of new jobs out there and new roles and positions in things that we never even thought of 5 years from now. And those are going to be a lot of the data sort of warehouses and tools that we turn to in the future.
Lisa, anything to add to that?
I'm not really sure that I do. I think, Abby, you covered that very, very well. Yeah,
okay.
So, I would agree.
Great. Okay, we've got a couple of questions here. They're sort of dense. I don't know if you can see them in the sidebar. One is from a digital. It says, from a digital agency perspective, we have a number of clients whose lawyers believe they don't have to be CCPA compliant, but we don't agree. This is the agency saying. The lawyers internally are saying no compliance required, but the agency thinks compliance is required. But our stance has been to defer to the lawyers. Is that right? If we're managing Google and Facebook campaigns and they should be compliant, are we at risk? Are we exposed if they're not compliant? The agency acting on behalf of the company.
So this goes back to how CCPA is defined, and if we just use the Google ecosystem, it's going to talk about who is actually the processor of the data.
So let me stop you for a second, because we've only got about 4 minutes left.
Yeah.
So what's the really short answer to that question?
So the really short answer is that we Bounteous say that our clients' legal teams, are the ones that need to be responsible for their corporate policies, right, as an agency. But at the end of the day, you also need to be aware of who is the processor of the data. And if your agency is holding on to some of this data and acting as a processor, then you need to consider your own internal best interests as well as it comes out to CCPA. Because if you believe that you are acting in a way that could potentially be flagged by the Attorney General, then you might actually want to push back again on this client a little bit, or get in writing at least, or document in legalese all of these types of things that you've been considering. Because ultimately, yes, your company does. Your client's company does need to be the one who's responsible legally, but if you are processing any of that data or acting as the processor, there could be implications for you as well.
Yeah, lawyers can be wrong. I know we're all surprised. And I think this raises a good point on CPRA, which is upcoming. Additional obligations on processors could be in the works. So just keep your ear to the ground.
Okay. Second question here is somebody asking about, is there an e-commerce site? They're asking about logins, right? So this goes to the first party data question. We don't have an account for our consumers. Will we be able to opt out consumers using their IP at a time of opt out? I'm concerned what will happen if they revisit the site from a new IP and get retargeted. So somebody on one computer in California, then they're on a different IP address and they're getting remarketing. Any suggestions on how to handle that? Will those users have to opt out more than once? Is it our responsibility to identify and opt them out across all IP addresses and devices?
So theoretically here, the question is, if they have multiple IP addresses, they're going to have multiple user IDs in the browser, right? If there's no logged in experience. There's really, not much we can do technically to forecast what their future ID will be. The best case scenario is that, yes, they will need to continue to opt out of the cookies if they are sort of choosing to come back to their site as a new user. Because we, the company, have no way of knowing if they were the same individual from the previous opt-out. It puts a heavy burden, to Greg's point, on the user to continuously opt out of that environment. And I think, the legislation is only going to get more and more granular on this, but it's going to be really hard for, you, the company, to ever be able to prove that you could tell the difference between these users. So yes, the user experience will be really heavy here, and they'll have to continue to opt out.
So, Katelyn, I want to ask you in the most Twitterific version of this that you can give us. What is CPRA, just really succinctly?
CPRA could be enacted January 1, 2023, and then effective July 1, 2023. It would modify the CCPA, adding.
It's a California ballot initiative that's going to be on the November ballot.
Yes, exactly. And in a tweet, it would add a category for sensitive data. It would place those additional obligations on processors, and it would create actually a new enforcement agency. So all of these conundrums we're talking about with the AG would be put on a new agency.
Okay, so tightening up the CCPA and creating a dedicated agency for enforcement purposes. Okay, so we're at the end of the call, but I want to give you guys, if there's no more questions, it looks like that there aren't. I want to give you guys each a minute to say one or two things that you want these people to be thinking about before they go to bed tonight about CCPA and what they should be doing or thinking. So, Katelyn, why don't you start?
I want you to have good dreams and not think about this before bed at night. But I do, when you're at work, please understand the points of data collection on your sites, understand the tools you're using, know what personal information you're collecting, how it's characterized by the CCPA, if it's sold, who it's being sold to. I think just be as familiar as possible with that data. That is always a really good first step.
Okay, Lisa.
I will say that think about privacy as not a fleeting trend. This is here to stay. And so you need to be creating a system around you to be able to support privacy. These are going to be table stakes in order for you to build trust with your employees, with your clients, with your customers out there in the marketplace. And so hopefully you can use it as a differentiator for you over time as well. But know that it's here to stay, and know that more is coming, and that it's only going to get more robust over time. So now's the time to start if you haven't.
So before we go to Abby, just to emphasize that, Lisa, so privacy as an intrinsic part of your marketing and brand identity.
Correct. Yep.
Okay. And Abby, you get the final word.
Oh, it's a treat. I think that, build yourself a team to build on Lisa's statement, and make it a part of your operational key results, your organizational objectives. If you're going to be a part of the CCPA team, ensure that you have the time built into your roles as a group. Build a cross-functional team here to actually successfully continue to meet on this initiative. I want you to sort of leave thinking it's not just a one-man show. It's a team of cross-functional individuals in your organization who will make this happen. So if you're a marketer and you're like, man, I'm just trying to drive my advertisements, go to sleep knowing that there are other people in your organization that need to also feed in their perspectives and their organizational expertise. So get that core group of people together. Meet consistently. Don't cancel it every week because other meetings come up, and consistently evaluate what you've got going on. Because I'll tell you what, in the past 2 months, this, our understanding alone of CCPA has changed so much that I can only imagine it's going to continue to evolve. So that's my final take on it: is get yourself a good group of people around you that are also going to stay dedicated and continue to sort of ensure that you're moving in the right direction.
Okay, I want to thank everybody, especially the panelists, Abby, Katelyn, and Lisa, for your time and your thoughts, your wisdom. There's a ton of stuff we didn't get a chance to talk about that we could have talked about, but I think this was a great overview for people. And we will follow up with more content after this, and we'll post the video so you can rewatch it. Thank you to everybody who asked questions and who listened to the call. And we'll do more Live with Search Engine Land sessions in the future. Everybody who's in the United States, have a great weekend to the extent that you can go out and do anything. Enjoy yourselves, and talk to everyone later. Thank you all.